when I purchased this from Disney or from whoever resold it, who bought it from Disney, I already paid Disney for the rights. So since I own this, I can do whatever I want with it. And for me, that means turning them into VHS water bottles.
Yeah. That line of reasoning is so wrong, and I hate to say it, but this creator has no bearing or sense of how intellectual property law works. So let's take a moment to comment on what she's talked about. And full disclosure, I know nothing about Kale Road Vintage or her products. I was tagged in this video before she eventually took it down on TikTok. But let's comment on it and talk about what she's just flat out wrong about. By the way, if you're new to my account, my name is Tony Oyakostas. My students call me Professor T, and I'm an adjunct professor of entertainment law and IP at New York Law School. And this is my 4th year teaching intellectual property. And I have to say, in all my years working in IP, which spans just about 9 years, and in my years teaching, this type of logic just does not add up. It makes no sense whatsoever. So I think the best place to start is to educate people on what copyright is and what happens when you create a copyrighted work. So at its core, copyright is an original work of authorship fixed in a tangible medium of expression. And the 3 buzzwords we should be paying attention to are originality, fixation, and works of authorship. Originality simply means that there has to be some degree of creativity. It doesn't have to be something ornate or grandiose, just something that at the bare minimum meets that creative level that can qualify as originality under copyright law. Fixation under the Copyright Act of 1976 means that something has to be perceived for more than a transitory duration. So there has to be some type of permanence to it. So when you take a selfie, that permanence takes place when that photo is stored on your memory hard drive. Or if you were to draw a painting on a canvas, the act of you taking a paintbrush and drawing on the canvas creates that fixation. And then finally, works of authorship. There are a number of different works of authorship that qualify as copyrighted works. So we could talk about music, film, television show, artwork, sculptures, anything of that sort. They're all enumerated in the Copyright Act of 1976, and you see them in full effect here on screen. So once you have an original work of authorship fixed in a tangible medium of expression, it's important to note that you creating that work of authorship makes you automatically the copyright owner, but you can reinforce it by way of copyright registration with the U.S. Copyright Office. But in addition, under the Copyright Act of 1976, there are 6 enumerated rights that are granted exclusively to copyright owners in such a way that if somebody were to ever infringe on any of these rights, that would give the copyright owner reason to go after the infringer and sue them for copyright infringement. So for example, if you were to create an original work of authorship by way of a selfie with your friends at lunchtime, that would make you the copyright owner of that photo. And under copyright law, that means that you have enumerated rights that are only afforded to you as the copyright owner. So you have the ability to create a reproductive work out of that photo. That means that you could print photos of that original photo. You also have the right to create derivative works out of that. And if somebody wants to create a derivative work out of your original photo, you can grant them the right by way of a license agreement. And then you could also have public display rights, so on and so forth. But if at any point somebody were to violate any of your rights under the Copyright Act of 1976, 17 U.S.C. 106, that would give you, the copyright owner, reason to go after that person infringing and sue them for copyright infringement. And basically, for a copyright infringement to succeed, you have to have a valid copyright, aka you have to have an original work of authorship fixed in a tangible medium of expression, and it should be registered in the U.S. Copyright Office. One of your exclusive rights under the Copyright Act is violated, and then in addition, the copyright owner must possibly plead that the infringer had access to your original work, and what they created is substantially similar to your original work of authorship. And then comes everybody's favorite defense that is so used and abused on the internet: fair use. People have done this time and time again, especially on platforms like YouTube, where they just literally rip off clips from a movie and they upload it on YouTube and say, no copyright infringement intended, this qualifies as fair use. Well, that's a complicated argument to make, because essentially fair use operates as a defense to copyright infringement so long as you're using somebody else's copyrighted work for criticism, commentary, news reporting, teaching, scholarship, or research. If you're not using it for any of those reasons, your fair use argument is just going to fall flat on its face. But if you are using somebody else's copyrighted work for criticism, commentary, news reporting, teaching, scholarship, or research, then you can go through a 4-factor test that helps assess the strength or weakness of your fair use argument. And those 4 factors include the purpose and character of the use, including, is your use of somebody else's copyrighted work transformative enough that it has new purpose, expression, meaning, or message? 2, you look at the nature of the copyrighted work. 3rd, you look at the amount and substantiality of your use of the copyrighted material in proportion to the copyrighted work as a whole. And then finally, you assess the market harm. Is your use of somebody else's copyrighted material so harmful that it could cause a detriment to the original copyright owner? Now, the thing with the fair use test is that it is a very fact-driven argument. So at the end of the day, it's all going to depend on what the facts say. If the facts show clearly that there's a viable fair use defense, then we have an idea of how that argument's going to go. But if your argument is so weak in arguing fair use, then odds are you're more likely than not having committed copyright infringement. So now that we've laid the legal groundwork for copyright law, copyright infringement, and copyright fair use, let's break down what this creator is saying about her being able to buy a Disney VHS tape and that purchase creates a license between her and Disney to do whatever she wants with it. I'm sorry to tell you, Keel Road Vintage, but you are completely wrong on this logic. So first, let's identify all the copyright assets on this VHS tape alone. She's holding up a Peter Pan VHS tape. So clearly the character rights to Peter Pan, Wendy, Tinkerbell, the Lost Boys, any of the other characters on this cover, those are all protected under copyright by Disney. We can also argue that the overall design of the VHS cover is protected also under copyright law because it's not just the characters themselves, but the way the poster on the front of the VHS tape is arranged. That presumably is protected under copyright law, but putting aside the copyright aspect of it, blatantly there's a visible Disney logo that is protected under trademark law. Disney is very protective of its IP, so you better believe that Disney, Walt Disney, even the Cinderella Castle, any variation of Disney is protected by the U.S. Patent and Trademark Office as registered trademarks. Now, the next question I need to ask is, if you are using this under the fair use doctrine, where's your criticism? Where's your commentary? Where's your news reporting, teaching, scholarship, or research? Have you transformed this original work of authorship in such a way that it has new expression, meaning, or message? Have you caused potentially market harm? Is this a small portion of the cover art, or are you using the entirety of it? At the end of the day, the fair use argument just doesn't add up when you're literally pasting cover art from a VHS tape onto a water bottle. The logic does not make sense whatsoever. Not to mention, you have to ask yourself, am I the creator of the Peter Pan character? Am I the creator of Tinkerbell or Wendy or in any way any of the other characters of Disney's Peter Pan? If the answer is no, then that should be a hard line stop for you to not pursue anything or do anything of this sort unless you've gotten a proper license from Disney, because odds are this is blatantly copyright infringement. I could even say that this is trademark infringement for sure. Now, one thing we really didn't touch on in this video yet, and I've been alluding to, is that what this creator is doing could actually qualify as trademark infringement as well. And the heart of trademark infringement is that if you're using somebody else's mark in such a way that it could cause consumer confusion, that could give the original mark owner reason to pursue a trademark infringement claim. Ironically, Disney has done this type of thing before. They recently had on shopdisney.com a whole line of different journals that you could buy that looked a lot like the old school VHS cases they used to buy at your local electronics store. So for example, what we see here on screen is a Little Mermaid journal that looks like the VHS case that we used to get when we were growing up. So Disney has done this before. What's not to say that if somebody were to look on Etsy or wherever this creator has her water bottles available, that this could amount to some type of consumer confusion, that somebody could say, oh yeah, this is a Disney product. This is officially from Disney. Not so fast. But I think what bothers me most about this video is that this person thinks that buying the VHS tape gives her an automatic license to do whatever she wants. And that's just a fallacy right there. Buying anything that is physical in nature, just buying a Blu-ray or a DVD does not mean that you are acquiring the IP rights. Buying physical assets just means that you are physically the owner of that asset. That doesn't mean that you are the IP owner of that asset and you could do whatever you want with it. Now, this video was taken down by Keel Road Vintage, and rightfully so, because I think that this video is IP misinformation at its finest. There is nothing accurate about what this creator said in her video when it comes to using somebody else's IP to upcycle into water bottles, which is what she's doing. And also, it's very interesting that this video came out fresh off the heels of a headline where Disney is suing a business owner in Kissimmee for basically selling unauthorized Disney merchandise, even after they had received a cease and desist from Disney and blatantly ignored it. So, I mean, honestly, if that happened to them, this could happen to any other creator that is playing with fire when it comes to Disney's IP. And I hate to tell you, Keel Road Vintage, but your use of Disney's VHS tape covers is exactly that. Not just playing with fire. You're just might as well jumping into the bonfire at that point. So please know that this isn't me bashing you, but I'm just frustrated that this kind of information is getting out there. And that's why I'm on a platform like TikTok or Instagram trying to share this information, because I think it's important for people to know that there are bright line rules in the intellectual property space, and there are things that you can do and cannot do. And this is the one circumstance where what you're promoting and what you've said in your video is just flat out incorrect. So good luck to you in any way, shape, or form, whatever your business leads you. I hope for your sake that you do not get a cease and desist from Disney, because if I'm being perfectly honest, this feels like infringement central.